IP friends, hot gist, real breaking news. Like this is a special episode for me because I just did JJ wait for her. I'm like, let me patiently wait until I do the podcast episode, and then boom, it landed in my DM. But yeah, welcome to IP series with Rita. My name is Rita Allen Richinda. I am a lecturer and an intellectual property lawyer based in Rivers State, Nigeria. Yeah, proud degree girl, proud degree lawyer. But not talking about that. But if this is your first time listening to my podcast, I talk about recent cases and development from copyright, trademark, patent, industrial design, trade secret, plant variety, and geographical indication. Now, if you haven't listened to my previous episode and you've created something, maybe built an you invented something, consider filing in South Africa and Nigeria under the SANI filing system. And for my returning listeners, you guys already know the drill now. Thank you for always coming back to listen to me, for your comments and feedback. It means the world to me. Like when I read your comments, it just bring from chain to chain. Yeah, but yeah, let's get into the hot gist I have for my IP friends. So first, I'm going to give you the breaking news regarding the Domitila reboot case. Now, remember or recall that in one of my IP series contents or post, I had said Annie Jamaze, who was a star of Domitila in 1996, filed a suit sometime last year at the Federal High Court. And in that suit, she was asking for certain things: injunction, an atom pillar, attorney's fee, etc., etc. Now, turns out that she has a motion before the court for an urgent or emergency hearing for that suit that was filed um, before the court. Now that suit or that matter came up 2 days before the Christmas holiday. However, the defendant counsel, now that's the defendant in this case would be Zebejiro, Film One, and Film Tribe, filed a counter affidavit to her application. And when she and her legal counsel found it or saw it, they caught cold cash it. Like they never expected it. And then they decided to file a new motion now for discontinuance on the assumption that the case of the preliminary objection challenging her competence, right to use and register Domitila and device as her trademark um, would not fall through. And because she and her legal team filed another suit this year against Zebejiro, Film One, Film Tribe, Zion, Zion. I think this is Zion's, but let me confirm. I'll confirm the last person, and then Zebejiro's film production company. um, she decided that she would drop the notice of discontinuance, which basically serves the purpose that she was withdrawing the lawsuit from last year, and so the Anton Pillar order will no longer exist, because basically an Anton Pillar is like a civil search order where an applicant, someone who owns intellectual property rights, can apply to the court that the court should intervene, um, else serious damage will be done, and there's a possibility that for instance, the defendant, who in this case is Ebejiro, Film One and Film Tribe, will destroy the documents or property of the infringing work, which is the Domitila and device, if they were not put on notice. So you basically need to put the person on notice so that it can be seized and preserved to be used as evidence. Now, this type of remedy is used for emergency purpose, and I'm also aware that some equipment were seized for this purpose. Another good thing is that, so what I need to say is that the first case for discontinuance was between Zebejiro, Film One, Film Tribe, while the second suit that she filed this year, after she discontinued the lawsuit, was against Film One, Film Tribe, Zebejiro Production, and the other film company that I was talking about. Now, the court, in his wisdom, did not grant her the order stopping Zebejiro and 5 others from showing the movie today at the cinema. luckily, today is the day that the movie premieres at the cinema. So if you are excited about this case and you want to help the parties involved make their money or live up to the reboot, I mean the premiere was, would I say, I'll say it was glamorous. Yeah, that's it for me. But if you want to help them celebrate, because there was a premiere as well, the drama, you know how the A-list actors like to do, everyone comes all out, everyone is looking glam, and the rest of them. So she also filed, like I said, that she filed a new suit, but with the same prayer for an injunction, an atom pillar, which was brought by an ex parte motion, meaning that the other party was not put on the show. So emotional notice is you're pre-informing the other party that this is what you want to do, whereas an ex parte, you're not even giving them notice, you're taking them unaware. So there was a motion for urgency to be held during the Easter vacation, which the Federal High Court already commenced their own Easter vacation early this week. I think it was a Monday. Um, yeah, early this week. I was like 3rd of April. So her atom pillar motion could be heard during the Easter vacation break. Now, it also turns out that counsel for the defendant also filed a counter affidavit to that motion, and now the court has ruled on the issue of urgency on the 3rd of April and on the competency of the atom pillar, which she had put forward as well. The court observed that the notice for discontinuance for the matter, which was filed in 2022, was yet to be attended to, and so the matter has now been adjourned to the 16th of May, which is like 2 days, no, a day before my birthday. My birthday is 17th, and 2 days before the 3rd anniversary of IP Series podcast. So looking forward to that. I think that will also be, struck out. Anyways, moving on. So the second suit which was filed this year also came up during vacation for the court to grant leave. So I think the leave will be to prevent Zebe Juru, Film One, and Film Tribe from, premiering and showing Domitila reboot in the cinema. And also, the court also observed that the character of Annie Jemanze and her lawyer in bringing cases during vacation was very I'm trying to look for the right word, but the court did not appreciate that particular act of them always looking to file suits during vacation. I mean, vacation courts are mainly for emergency cases, and the court clearly said this is not an emergency, so I'm not going to grant you your request. There are two ways that I need to say that you can end the case. First way is that if the defendant, who in this case is Zebe Juru, did not file a defense, then you just file a notice with no leave in line with Order 50 Rule 2 of the Federal High Court, which the judge also referred to in their ruling. However, in an instance where the defendant joins issue with you, like Zebe Juru and the rest did when Annie had filed her suit, you would need to apply to the court to withdraw, because they have spent time to respond and they also have the right to be heard, which is why the matter was adjourned to the 16th, etc., etc. And then again, for interlocutory application, which I said you need to put the other person on notice, it requires that this Zebe Juru and the 4 other parties to be put on notice before the injunction can be granted, and the application was struck out for being incompetent, and that is the court decision. So if you come across it, this is like a brief explanation, but social media headlines will tell you, yeah, the matter has been discontinued or dismissed. I know the Sahara reports that I was also forwarded. I'm trying to get to it now. Hold on, guys. My allergy is acting up as well. So if I sound funny this morning, please forgive me. My allergies have been acting up since I woke up. But yeah, so many messages, but okay, I think I just found it now. So this Sahara report says court dismisses the Nollywood actress's ex parte application against fellow movie. Now I'm now going to go into the main issue and how we got to this point where the court is now dismissing or refusing to grant any of her application, and she not having the right to also prevent Zebe Juru and 5 others as Film One, Film Tribe, and the other parties that Zebe Juro's production and the other parties involved as well. So yeah, let's discuss the do's and don'ts when it comes to trademarking a movie character. So I'm going to start with what the trademark is, and then we move into other elements, relevant elements of intellectual property as well. How did we get to the court dismissing this? So Anne Choma and Jemaza, who played the role of Domitila in the 1996 Nollywood classic Domitila, had previously sued producer and director Zebe Jiro, Film One Entertainment, and Film Tribe Media. That's the initial suit of 2022 for trademark infringement of the character name Domitila and passing of which she apparently applied for a trademark 16th of September, and in her claim she was asking the Federal High Court in Lagos to grant her an injunction against Zebe Jiro, Film One Entertainment, and Film Tribe Media. Also asking for an account of profit, which is like available remedy. So if you sue someone for infringement, you have remedies that you can rely on. Yeah, remedies that you can rely on, such as account of profits, injunction, Anton Pillar, etc. So she was also asking for 50 million naira as damages and 5 million as cost for litigation and attorney's fees, and that Domitila reboot be destroyed, basically. So that's like the summary of her claim. Yeah, but now let's get into how she got to this part. So it's like it's doing like our throwback edition, sort of. So sometime in November or December 2021, Anne had been approached. So Anne was approached to star in the movie 24 years after she was the star of the movie. She was star of the movie and lead actress anyway. Zebe Jiro reached out to her for casting to feature in the reboot, but negotiation broke down between parties as to the exact amount of payment for her role. It also turns out that she was given an NDA, which she ended up signing. There was also discussion as to her schedule was being considered as well, but the fee was just the issue. When and so basically in a business you best just negotiate, and while that was going on, Zebe Jiro's team was like the price she had called was ridiculous and not in line with the industry standard in Nigeria, and so conversation broke down. And in all of this, she never even mentioned that she had applied to trademark the title Domitila, especially because you know that the process of registering a trademark is not the same as trademarking it. So I'm in the process of registering it, and someone who has a trademark certificate, they're two different things. Now, Zebe Jiro finished the movie, and it is premiering today, Kakan 7th of April, and they have the right to air. And they also have to, sell to a third party to help them with distribution and all of those things. So Zebe Jiro and two others, this Film One and Future, that alleging that Anne's application to register the title of its cinematograph film as Domitila was done in bad faith, on the grounds that her act was going to interfere with Zebe Jiro's production, his continuous use of the name for his movie Domitila, which he had used in 1996, and also I think, hold on, apparently the movie was shot in 1996, 1999, and now 2023. So it's clear that Zebe Jiro has a series for the Domitila movie as it stands. Do you guys get that part? Yeah. They are also alleging that the trademark infringement and Anne's registration was an afterthought, and I think I would agree. That's my own personal view, because like I stated, she should have raised that as a point of conversation. Oh, so guys, I registered, or I am registering a trademark for the lead character role that I did, just to inform you guys. But now the question will not be, does she have the legal right to do that? I hope as we converse, I would be able to answer that question as well. Um, it was an afterthought, and she wasn't given the right. She was also given the right to of first offer as the lead character in 1996. And in that application that I saw, it was Anne's photographs, name and image that were used in her application. And for the Domitila movie, no, as in the current Domitila movie, it's not, you're not seeing Annie Jemaze's name or face or image used for promotion of the film. So it's a bit, I don't want to use the word weird, but it's funny. I think that's safer. I think it's just funny why she would assume such. So I think, let me just go through. Yeah. So I'm looking at the flyer now. You have Stan Nze, Uzomaka Anoha, Onyeo Okoro, Odokoro, DME, Akan Lawan. He was popular during and after the election when Banky W lost, but I don't know how relevant that is anyways. He also have Ejiro Onojiafe, Teniola Aladese, Iyabo Ojo, Chiwetalu Agua. I think I need to watch it because of Chiwetalu. I don't know. They also have Franca Brown, Sonny McDon, sorry, Chinyere Wilfred, and I can't see the last name. It's not really visible, but it's something. I think it's Elvina Ibru. Yeah, those are the list. Those are the people whose images are being used and photographs are being used for the promotion of the film Domitila. Now, if you have read the defendant's um response to the suit, the statement of the defense, they also referred to the agreement between Anne and Zeb Ejiro's production as part of her acting service, which mandated her not to misuse any confidential information shared, and was also found as in that after the contract to not disclose any trade secrets or confidential information belonging to Zeb Ejiro. Maybe if we want to expand this to include other IPs and things like copyright. I mean, I like to stick to just copyright and trademark anyway, but I think we're also going to expand her contract. Was there a timeline as to how long she should not disclose? I would want to assume that it's the recent agreement, which is the NDA, which she signed when she was approached, that mandated her not to misuse any information shared with her. So trying to play a fast one will not lead you anywhere. But Zebe Jiro and Film House are alleging that Anne's application to register the trademark in Class 41 was done to force Zebe Jiro into accepting her acting fee, which they consider to not be in line with the industry standard and practice in Nigeria. And also, can actors consider, can this act rather be considered to be a trademark squatting incident, or can Anne be considered to be a trademark squatter or a trademark troll? Who, I mean, this kind of people, their job is basically to register IPs such as trademark and patents, and then they wait for you to come, and then you have to do a negotiation. So it's more or less being done for economic benefit. And since Zebedee has been using Domitila since 1996, when he produced the first part and part 2 in 1999, and now the reboot in 2023, and has also advertised and promoted the film with Dark Communication Limited, owners of African Independent Television. Hey, okay. I think I'm getting really excited. So you will see that Zeb has put in a lot of effort to show that he has consistently used the mark or the phrase Domitila. Because for trademark, basically, we're talking about trademark. Trademark protects words, signs, symbols, But I want to refer to the, hold on, guys. So we have a new law in Nigeria called the Business Facilitation Act, where it defined um what a trademark should currently be under Section 67 of the Nigerian Trademark Act, which is the interpretation act. So the new definition for trademark is trademark can be used or proposed to be used in relation to goods or services. Before, services weren't included. Well, now goods or services have been included to indicate a connection between the goods or services and a person having the right, either as a proprietor or as a registered user, to use the mark, whether with or without any indication of the identity of the person, may include the shape of goods, their packaging, and combination of colors. Now, one thing we need to know again about trademark is that its main purpose is to prevent consumer confusion. Would consumers of Domitila, the original Domitila, link it to Annie Jemanze? If you can answer that question, then that means a trademark infringement actually exists or passing of exists. But if you cannot find any link, then there's no case. Basically, will there be a likelihood of confusion amongst the movie lovers over Zebi Jeru's Domitila and Annie Jemanze's trademark application? I think not, and that is just my own personal view, and I'm not a judge to give a final order, but that's just how I see it. Like, if I see the movie Zebi Juru, or sorry, if I see the movie um Domitila, I would first think of the producer and not even the actress. I mean, the actress might come in terms of maybe you're trying to tell the story to someone. You'll be like, oh, don't you remember this actress that played this role? She was the lead role, our lead actress in that movie. So trademark as an IP mechanism functions as a source identifier. It helps distinguishes a movie brand from another movie brand, say their competitor. Now, is Anne a competitor? No, Anne is an actress that her services were rendered and terminated after the movie ended 24 years ago. It also serves, let people know that okay, this thing is a quality product or service. So what are those do's and don'ts of trademarking a movie character that we need to take note of? First, if you're going to trademark a movie character, you need to do a search. Do a trademark search. I mean, the easiest search to do is to put it in Google, find out if there's a trademark existing for that. That's, um saves you money as well, before you can think of engaging a lawyer, not just any lawyer, a trademark attorney or law firm to help you to do a search with regards to the character, so that you verify that there's nobody already using that character as a trademark. Now, if you notice, big film brands have character merchandising or other sort of merchandise for their products or their films. You need to also work with an intellectual property lawyer versed in trademark or a trademark law firm to help you register your trademark for that character. Make sure you also monetize it, because one of the benefits of trademark is that as long as you consistently use it, you do not abandon it, you're not, just leaving it there. No one is going to apply that your mark be cancelled for whatever reason they choose to give. You also need to use the trademark symbol when you've done your registration. So for a registered trademark is R in circle, while for unregistered is TM. So when you see TM beside the name, just know that that mark has not yet been registered. Then you need to figure out how the name and logo or device will be used to establish ownership, so that you prevent potential copiers, people that want to take advantage of your reputation. For instance, now this morning I'm saying that the LUP guy Steven has put out a cease and desist notice telling people you are now they put on notice, you can't use LUP without my consent, and conversations are already starting as to what right he has for his unregistered trademark, because this was like a month ago, 25th of February, when the election took place, and today is 7th of April, which is the premiere of the Domitila reboot movie. So let's say a month and a couple of days, and you're already putting out notice. But then, I've seen jerseys with LOP, I've seen a fizzy drink, and then I'm aware of a merchandise collaboration which he did as well. So stuff like that. That's why you also consider, trademark options during your search and putting out the symbols as well. You need to also monitor and enforce your trademark so that you prevent other people from using it without your permission. You get it? Yeah. Now, the don'ts of trademarking a name. Don't use a character that infringes on someone else's trademark or intellectual property. Like this case now. And Jemaze don't wrong go apply say she won't trademark Domitila and device. Meanwhile, Zebejiro don't they use it since 1996. You guys. And the question now is who is infringing on whose intellectual property right? You get. Then you don't need to assume that because a character is not registered as a trademark, then it's available for use. So because say Zebeju no register, you no register Domitila, and can say I still no do make her go down. But then again, you have issues where because we apply a first to file IP system where the person that files first that gets priority. But then you don't have other loopholes in that conversation where you are considering if the person has consistently been using it, like has for Giuseppe to move from 1996 to 1993 and now 2023, 24 years after, it shows you that this person has intention. So you also have instances where someone has the intention to use a mark and also want to just do like a defensive registration, but this is not a defensive case right now. You get you formally then you don't neglect to enforce your intellectual property rights, which could lead to loss of ownership. And also you can also wait until after your film is completed to start the trademark registration. So I think going forward, what filmmakers can do, you know verify or make sure that the mark you want to register in question or the character you want to register in question is distinctive or capable of distinguishing your mark so that it qualifies for trademark. So that those are like the basic requirements for trademark registration in Nigeria. Under section 9, it has to be capable of distinguishing, capable to distinguish. I think that's how the law puts it. And then being distinctive. You get. Then you need to formally apply to the trademark registry, do a search, apply formally, wait for your acknowledgement and acceptance, and then wait for opposition or publication in the journal and opposition as the case may be. Then in the case where your fictional character such as Domitila, in this case now your fictional character such as Domitila cannot be similar to another character already registered as a trademark or even enjoy the goodwill and reputation of a registered trademark under common law. So I would say Domitila already enjoys the limited protection granted to unregistered mark under the common law, where you already have goodwill and reputation, all of those fine elements. Now let's move into the statutory requirements for registering a trademark. So I'm going to list out a couple of sections I think you guys could pay attention to and that can also follow as defense to trademark, and we'll move on to elements of passing off, etc. Please stay on the line with me. I will stay on this episode with me. I don't know. Now, what are the statutory requirements for someone who wants to do a trademark registration within Nigeria? First, the effect of registration and non-registration under section 3. Now that section provides that the owner of an unregistered mark already enjoys limited protection and has the right to sue anyone who uses their mark without their consent for passing off. However, in an instance where an unregistered mark existed first and Annie Jemanze was aware, she is aware that Domitila existed before she even got a contract. You already know that when you're considering making a film, it begins with a script and a contract with the script writer or the person who does the treatment, and then develops into what it ends up being. There are also considerations such as raising funds by leveraging on your film's unregistered or registered trademark, so you attract sponsors and investors. And when a film or a television project happens to be part of a series, the title may qualify or act like a brand and indicate that each movie comes from the same source as others. Like we've seen in this case now that Zebejiro has a series from 1996 to 1999, and 2023, and that Domitila can be linked to him and not an Ejiro, as the case may be. So Anne is already aware that Domitila exists, and her art can be considered to be done in bad faith, which, I mean, the goal for doing that is um passing off. You want to misrepresent Zebe Jiro's um movie, or you want to associate you want people to associate your mark to Zebe Jiro's. Kind of like you're basically just misleading the public with your action. Then look at what amounts to trademark infringement under Section 5 of the Trademark Act. Now, first, what is a trademark infringement? This is when someone uses your trademark without your consent, permission, and authorization in connection with a goods or services to which it relates, or in a manner that is likely to cause confusion or deceive the public. So, if I'm using Domitila now, so that people can say, oh, Domitila na that is Zebejuru movie, Phoebe, yeah. Or I want to deceive the public and say, okay, now and don't register Zebejuru for class 41. Now me say I should get the mark. You know, all those kind of conversation. So under section 5, what the law provides is that and who is now suing Zebejuru, Film One and Film Tribe Media must show that the use of Domitila is identical or nearly resembling her own, and not because she is a prior user, because we do not apply the first to use principle in Nigeria. Also, that Zebejiro using Domitila was done to deceive the general public. I mean, I know when the publication came out that Zeb was going to do a reboot, no one was thinking of Annie Jemanzi. Clearly, I mean, you sure me die. Say nobody did think of Annie Jemanzi. Everyone was talking about Zebejiro, and even at the premiere, I think I saw a an Instagram post where he was being interviewed, and I was like, cool guy. But other parties involved, such as the Film One and Film Tribe, would you say their action was done to deceive the public that, oh, this Domitila where we won't use now and Jamazi get that? So you know what really amounts to a trademark infringement. You need to consider that. Then you also need to consider the right of a prior unregistered user, which section 7 talks about. It protects unregistered mark that were in continuous use, and I would say Zebedira have done that from 1996 to 1999 and 2023 7th April, where the movie is premiere. I don't know who's going to watch it, but I think if you let me know. So I think if you would love to watch Domitila the reboot, I stay in Port Harcourt first of all. So if you're in Port Harcourt and you're listening to me and you would love to watch Domitila the reboot, send me an email to ipseriesinfo@gmail.com. It's first come first serve, first person, and this is like, it's not, I won't call it a giveaway, but I'm just excited that I have to watch same way I watched them, what's it called now, Oloture. Yeah, that was on Netflix. I don't know if this is going to premiere on Netflix, but right now it's currently showing in the cinema. So if you love to watch Domitila the reboot, send me an email. Whoever sends it first, I'll buzz you and we'll pick a date and time in any of the cinemas. If it be Kada, or if it be Film One or Genesis, whichever one is comfortable for you. Yeah, so movie date with Anwuri to watch Domitila the reboot. But if you also stay in Lagos, like, because I know I have listeners, as in most of my listeners are from Nigeria, so I wouldn't want to sideline anybody. I've not been in Abuja in a very long time. It's a couple of months now. But Lagos and Port Harcourt ain't get me. So if you are based in Lagos as well, if you're sending that email, please include your location so that I would know when I'm reading it. So Port Harcourt, I would like to go on a movie. I won't call it a movie, they just call it an IP series hangout. Yeah, an IP series hangout with you to see Domitila reboots based in Port Harcourt, you know. And if you're based in Lagos as well, I hope I get into Lagos this month. But if we don't, and you send me an email, I owe you a movie as well whenever I get into Lagos. Yeah, let's leave it that way. But I would have preferred that it be the Domitila reboot anyway. But moving on. So under section 7, right of a prior unregistered user, like I was saying, that the section protects unregistered trademarks such as domitilla that have been in continuous use before the date of the registered mark, which in this case is still in the process of being registered or in the process of being registered, right? And the application commenced in, 2021, when they had reached out to Annie Jemaze. And Jemaze also need to demonstrate that Zeb Ejiro's use of Domitilla occurred after the registration of her trademark, while Zeb Ejiro must show proof of use prior to Anne Jemaze's trademark application in 2020. Sorry guys, it's 2020. Missed the date. Or rather the year. And then she must also show evidence of distribution, goodwill that she has obtained. Sorry, Zeb must also show evidence of distribution, which he has, listed with DA and AIT. AIT. Yeah, and now with Film One, Film Tribe, and the rest of them, goodwill he has obtained from the continuous use of Domitilla, and that he never abandoned the registered trip. I would say he never abandoned. I mean, someone who went as far as, you know, doing a reboot and is premiering on the 7th. Doesn't that show you that the person still has intention of using it? He never thought or had the impression of abandoning it. So I think so far it's not looking good for Anne, but I'm not the judge. You guys, I wouldn't mind being an IP judge someday, but for now I'm still a lecturer and still an IP lawyer. So let's stick to advocacy and educating people. Yeah. So next up is rights and legal requirements to apply for registration under section 18. And first, the trademark in question must be a product or service. So it could be in form of a name, word, device, or color of the proprietor. Second is that the applicant or the application must be filed together with other documents required. And third is that you must have the right to demand the ground for refusal or conditional acceptance in the event that the registrar refuses or conditionally accepts your application, which can be appealed at the Federal High Court, who will make a pronouncement of whether the application should be accepted and then the grounds for the acceptance. So basically, because I've had that experience where we're doing the trademark registration and it didn't go through and we had to appeal at some point. So these are the instances where you have the rights and legal requirements to actually apply for a trademark. So this is what section 20 sorry, this is what section 18, I think I need to drink water right now, but this is what section 18 provides. Next up is section 38, and this is one of the sections that I would love you guys to really pay attention on. And this talks about rectification proceedings, which are used when a registration is considered to have been made improperly, unlawful, fraudulent, confusingly similar, deceptive, or in violation of the Trademark Act. Then it can be struck off the registry. And this proceeding can be triggered or commenced by any concerned person. So let's use our live case now. Zebejiro can trigger this proceeding if he wants to. If he wants, he has a good lawyer on his team. So I'm sure Mr. Roxy will do a fantastic job. If they've had the case being thrown out, I think he has done so well with that. Just waiting for the other though application was not granted. Court had dismissed that. So I would say fantastic job so far, Mr. Roxy. But let's talk about defenses. What are the defense available to a trademark infringement? So someone has accused you. What are you going to say to stand up for yourself? Would you say the use of that trademark was for non-commercial purpose? Is Annie Jemaze registering the trademark so that she will not make money? I think that's impossible. When you're talking about defense of fair use, the main purpose is that you're not making money from that. So if you're going to be making money from registering a trademark, that's the whole purpose of registering a trademark, because you want to make money. Another defense is non-registration. Another one is abandonment, meaning that you've abandoned the trademark. Another thing that will be considered is did Zebedee at any point abandon the use? I think so far from my conversation it's obvious that he hasn't, and I don't want anyone listening to think that I'm so much in support of Zeb, because I'm basically giving my view on their actions, then the next defense you can opt for is right to use and own a name. So if you recall the Amotala case when it was viral, everyone was talking about it. She's going to prevent other people from using the name, etc. But that is not in relation to that. When you're talking about right to use and own the name, you're referring to the fact that for the product or services, that is what you're going to be doing, using the name. Finally, oh, it's about to go down. So finally, what are the lessons, intellectual property lessons for those in the film industry? One, always retain the service of an intellectual property lawyer or law firm with expertise in film law. Every creator in the film industry should learn about the Beijing Treaty on Audiovisual Performance. I just read some sections of the new act talking about the visual rights and performance rights. So learn about, take your time to learn the fundamentals. That's the only way you can be able to equip yourself. They always say ignorance is not an excuse. You get it. Always identify and document your intangible asset that has commercial value by registering them at the intellectual property office in your jurisdiction. For instance, if you are based in Nigeria, do your registration in Nigeria before you start considering other jurisdiction, if you get the money, sha. And then finally, Darren Tang, who is the current DG of the World Intellectual Property Organization, WIPO, stated that intellectual property plays a critical role in supporting creators that from all parts of the world to succeed, from script to silver screen. And this comment was made after what was that famous award now that Angela Bassett did not win? Trying to remember. I think I have issues remembering stuff, but that's an aside anyways. But yeah, so that's it from my end on this episode on the do's and don'ts of trademarking a movie character. Now, another notable defense when talking about trademark infringement is called the statutory acquiescence, which is explored when the alleged infringer relied on assurances or act or approval by the proprietor to use the trademark Domitila, which in this instance is Anne Njemaze, who has applied for a trademark in class 41 and has also been aware of Zebe Jiro's use, is now claiming that his use is an infringement after 24 years and still went ahead to apply for a trademark registration based on his conduct by reaching out to her. So this instance now is like when you're talking about an implied contract, someone's like, oh, by his actions he gave me the go ahead to use it. So maybe in her mind, or in this instance, if you find yourself in such a situation, you guys can argue that the person's conduct made you feel that they have given you their approval to use their trademark. I don't know, just saying. But this is one thing that I think, or one area of trademark that I feel people should take note of when you have like a trademark infringement suit. Now let's talk about passing off. What do you understand passing off? Passing off basically relies on acts that is done to cause some sort of damage or affect the goodwill or reputation of another person. It's also like a misrepresentation that has been made by the alleged infringer. It also aims to deceive prospective purchasers of the mark in question that this person is passing off on their goodwill and trademark, that they have experienced some sort of damage. So what damage would Anne Jumanzi claim? Because in her prayers, she was asking for a 50 million naira claim and also 5 million naira for her attorney fee, which is like, but then the defender countered and sued her. I mean, they were asking for 500 million. But one thing is to ask, another thing is to prove, which you have to do by way of valuation to show that that damage actually occurred. So have you valued the damage to come to the conclusion that, oh, that damage is actually worth either 50 million or 500,000 naira or 5 million naira, as the case may be. Then again, you need to consider the goodwill and reputation owned in the goods, the name, the mark, the device, whatever the trademark in question might be. Now, I'm going to read out a quote which I found very insightful while I was doing this research. So it's by Lisa P. Ramsey, who's a professor at the University of San Diego School of Law. She said, non-commercial use of another trademarks that falsely identifies the speaker or product source may be subject to infringement law, which I kind of agreed with her when I saw it. I was like, this actually came in at the right time. Now, I remember I said that this case has like a multi-layer of IP. However, parties focus mainly on trademark. I know I saw a couple of publications where they're referring to copyright, and I was like, how does Anne has the copyright to the Domitila movie? She'll get. But I think a colleague had alluded my mind to something, and I had to start. I was like, okay, this is also insightful. So, Domitila as a movie is a cinematograph film under Nigerian intellectual property law. We know that we now have a new um a new copyright law. So I'm going to read out what the law provides in terms of protection, because I was reading it the other day, and I was like, wow, I mean, you guys did well though. So our new copyright law, like what how did I term it? And there's a way I phrased it. I was like, our copyright law is as rich as the Nigerian um culture. Yeah, that was how I phrased it, because I was like, I was reading, I was like, on a trial, even if I felt like, I mean, comments have already been made that, oh, in light of the public hearing that was held and things that we've experienced post pandemic, certain things should have been considered as well. So I'm going to read um hmm, hmm, yeah, so I'm going to look at, so already the new act, which is the Copyright Act 2022 now, lists um artistic works, musical works, literary work, audiovisual work, sound recording and broadcast as works eligible for copyright protection. Hold on guys, I'm trying to confirm something. Let's see now. So what I was trying to confirm is that I noticed that under the old law there was a provision for so under section where they're talking about rights um given to that rights that are, so it's a copyright in a work shall have the exclusive right to do and authorize the following. So the old law, as Copyright Act 2004, had exclusive rights for cinematograph works. However, for this new act, I'm not seeing, I don't think I read anything on cinematographer, but what I did see was on audio visuals. Yeah, so there's an audio visual provision right now. Hold on. So now you don't have cinematograph work again, but you have provisions for nature of copyright in audio visual works, and that is under section 11, which provides that um the owner shall have the exclusive right to do and authorize reproducing the audiovisual work, to cause the audiovisual work that consists of visual images to be seen in public and of sound to be heard in public, to communicate the audiovisual works to the public, broadcast the audiovisual work, make any copy of the soundtrack of an audiovisual, make the work available to the public by wire or wireless means in such a way that members of the public are able to access the work from a place or and at a time independently chosen by them, distribute it to the public for commercial purposes, copies of the work through sale or other transfer of ownership, provided the work has not been subject to distribution authorized by the owner. Make an adaptation of the audiovisual work, make a translation of the audiovisual work or any part and do in relation to a translation or an adaptation of the work any of the arts specified in relation to the work under this section. So you see, I would say, this is just I think this is like the first comment I've made regarding the new law. Yeah, so this is like the first comment. So protection is also for a term of 50 years after the year end of the year in which the work was first made available to the public with the consent of the author, or 50 years after the work was created if not made available to the author. um that's under section 19. So I think for the copyright aspect, I'm just going to leave it there. I wouldn't want to push myself so much on the copyright aspect, but then let's wrap it up by discussing um so I see under so yeah, there's another aspect of intellectual property where actors and actresses enjoy performance right, and this new law now has express provisions for that under section 63, which talks about the rights of um performers. Yeah, let me go through section 63 now. And so it's taking a lot of time to get to the page anyway, but let's do it all the same. Section 63. I mean, this new act has um I would say they are very insightful and innovative provisions. However, they should have done a lot better, especially because we had a public hearing. So I'm just want to pass time now because I'm still scrolling to um get to section. I'm close now. Yeah. Yes. So I'm at section 63. So it says a performer shall have the exclusive right to control in relation to his performance, fixation of his unfixed performance, and this is not the issue here. Reproduction or fixation of his performance in any manner or form if the original fixation other than the fixation excluded by section 68 from the necessity for obtaining the consent was made without his consent. Reproduction, original fixation made in accordance with section 68. Distribution to the public by sale, broadcasting or communicating to the public, and unfixed performance, renting or lending, making available to the public. Then in this under subsection 1 of section 63, it stated performance will include dramatic performance, which includes dance and mime, musical performance, and reading or recitation of literary art or any similar presentation, which is a live performance given by one or more individual. In this part, performer includes actors, singers, musicians. That's subsection 3 of 63 now. Actors, singers, musicians, dancers, and other persons who act, sing, deliver, declaim, play, interpret, or otherwise perform literary or artistic works or expression of folklore, irrespective of whether the work was fixed or only fixed during performance. So what are the rights granted to a performer? The performer shall apply in respect to any performance on the dates of the performance. At least one of the performers is a citizen of Nigeria. I mean, if you read I think the first few sections of this new artist stated there, um, the performance took place or was first fixed in Nigeria or any country who is party to an obligation or treaty or international agreement. Now where the question arises as to country, blah blah blah, but we're not going to talk about that. Then he now went further to talk about section 66 now talks about moral rights of performers. So a performer shall have the right to be identified as the performer in connection with any use of his performance or physician, and was a performer in 1996. This is 2023. She's not the new performer. We have a new face. And so, I mean, you see that a lot with reboots, sequels, franchises. I mean, new faces every time. For instance, Superman, we have seen different versions of Superman, but what's that guy's name now? Can't remember his name. I was going to say he's my original Clark Kent, and then I think this other guy in Justice League as well. Oh, still can't remember his name. I think it starts from C. But anyway, as a performer, so if you're an actor, actress, you're a singer, whatever, you have the right to be identified as a performer in connection with any of the use of a performance or fixation. You can object and prevent any distortion. So moral right basically gives you the right that even when you have, if you decide that you want to sign off your moral right to, but then you can't sign off your moral right. You cannot do that under the new law because they said it's inalienable. It's in perpetuity. But sometimes you see people sign bad contracts, so that happens. But then you have the right to prevent any sort of distortion, especially when you've sold mutilation. Someone tries to go against what the principle of your movie, such as Domitila, is. You also have the your rights cannot be transmissible during your lifetime and even after your death. It can be transmissible by testimony disposition or by operation of law. The rights conferred on these items are substituted for the duration of the performer's right. Mm, Exceptions to performance right. I'm not going to read that as well, but I guess you guys already know um what I'm talking about. In relation to infringement of performance rights, it would include anyone broadcasting a substantial part of the live performance, importing, using it for trade or sale. But yeah, let's move on and close for this episode. I hope when you listen to me I've made sense. But if I haven't made sense again, you can always send me a feedback. Always open to your feedback as well. Yeah. So we have finally come to the end of this episode 96. If you listen to the end, thank you very much. I believe this is a long episode. But yeah, thank you so much for listening. Don't forget to like, share, subscribe, and don't forget the subtle giveaways I have. I'm still looking for my co-host for the 100th episode. If I don't get one, I'm still gonna do it myself anyways. The giveaways to see a movie, to see the Domitila reboot either in Port Harcourt or Lagos. You pick a date and time. I will make myself available for those in Port Harcourt. For the Lagos, my Lagosian IP friends, we will definitely fix a date. And it's just one person, guys. Please. Hey, Joe, just one person. Until then, see you in episode 57, which I hope will also be mind-blowing. But yeah, cheers guys, and have a fruitful week and happy Holy Week as well. Bye.